Hi, I'm Duncan. I am an attorney practicing in Newport Beach, California. I'm certified by the State Bar of California as a specialist in probate, estate planning, and trust law. I want to spend a few minutes today talking about saving time and money on trust litigation. But before I do, I need to make a disclaimer that I am not giving legal advice in this vignette. I am not addressing any particular case or set of facts, and most importantly, I am not your attorney, and I have not been engaged as such. You need to consult your own attorney if you require advice or assistance on a problem I have discussed in this video or any other legal problem that you may have. That said, I would like to focus for a moment on the subject of living trusts. I am particularly talking about living trusts in California, but much of what I am about to say is applicable in other states as well. In some situations, living trusts are great, but for the last 30 years, living trusts have been marketed as a way to avoid probate, avoid taxes, and in addition, marketing people have said things like, if you have a living trust, you will go to heaven, and if you don't, you won't. And salespeople have gone on with such things as, if you have a living trust, you will never have to pay any attorney's fees, and you will never have to pay any other types of fees, and you can do all the work yourself, and etc. But just the opposite is happening, and again, I'm talking about California. In California, living trust litigants are lined up around the courthouse, and these litigants are paying really heavy litigation expenses. The living trusts, which were supposed to save money, are costing everyone a fortune. These trust litigants are arguing about who gets property, who should be the trustee, whether the trustee should be removed, alleging mismanagement of trusts, and a whole host of other issues. Trust litigants are being motivated by emotional claims like, my brother is a no-good son of a gun, or my stepmother is the wicked witch of the West, and so on. The litigation attorneys keep arguing these issues with no end in sight. And why shouldn't they? They keep generating legal fees and costs, and no one is telling them to stop. Let me say at this point, I'm just talking about some litigation attorneys, not all of them. Some very competent litigation attorneys in a particular case have no choice for one reason or another but to pursue trust litigation to trial or other disposition. So again, let me repeat, I am only talking about some litigation attorneys, not all of them. So what can be done about this problem? Well, you can, in most cases, tell the litigation attorneys to stop the litigation. There are a couple of truths about trust litigation. Truth number one is 80% of trust litigation is either not necessary or it is not necessary to the extent that it's being prosecuted. Let me repeat that. 80% of trust litigation is either not necessary or not necessary to the extent that it is being prosecuted. Truth number two. Truth number two is that there is another way to go, a way to go other than trust litigation. Our office has been successful in getting cases out of the trust litigation mode and into a trust administration mode, and by doing so, maximizing everyone's dollars. Suppose, for example, it costs $200,000 for each party in trust litigation to take a case from ground zero to trial. And often, there are more than two parties in trust litigation. Wouldn't it be better to pay the money to a trust administration attorney, or at least some portion of it, to get the case finished as expeditiously as possible, rather than having long, drawn-out, expensive litigation? So what I'm suggesting is to get the trust litigation case out of the trust litigation mode and into a trust administration mode. I am talking about using strategies like mediation, collaboration, using fiduciary accountings, making disclosures, establishing trust and transparency, bringing in trust administration expertise into your case, in place of so-called trust litigation expertise, and getting everyone on the same page to maximize their dollars instead of letting the litigation attorneys keep churning the case on and on for attorneys' fees and costs with no closure, just more litigation fees and more litigation costs. In Charles Dickens' Bleak House, a will contest went on for many, many years, with the estate being eaten up by litigation fees and the beneficiaries receiving nothing. If you are in a Bleak House situation as a trustee or a beneficiary, you might talk to your attorney about getting your case off the litigation track and onto a trust administration track, where everyone can maximize their dollars and economy and speed are the rule of the day. And isn't economy and speed what we are after? Don't beneficiaries want their inheritance sooner rather than later? And don't professionals want to be paid? Doesn't everybody want closure? And doesn't everyone want to maximize their dollars? So if I have touched a nerve here with you today, talk to your attorney about speedy and efficient trust litigation rather than ongoing, unending, Bleak House type trust litigation. And if you are an attorney watching this video, talk to your clients about early termination of trust litigation and switch to trust administration. That is, put your case in an administer the trust out the door mode. Everyone can maximize their dollars by going the trust administration route rather than the trust litigation route. Well, that's my 2 cents about saving time and money on trust litigation. I hope you find it helpful.